Here in Germany, the Constitutional Court has ruled that Berlin is not required to take measures to supervise the activities at US military bases in Germany. The court rejected a case brought by two Yemenis whose relatives were killed in a drone strike in 2012. The operational data for that strike allegedly went through the US Ramstein airbase in southwestern Germany. Judges rejected the argument that Germany had violated the right to life by allowing this operation to continue on its soil. And we can now bring in Andreas Schüller. He is a lawyer, a co-director of the International Crimes and Accountability Programme at the European Centre for Constitutional and Human Rights. That's an NGO that supported the Yemeni plaintiffs in front of the court. He joins us from Karlsruhe, where the Constitutional Court is located. Now, you've been with that case for more than a decade. Are you surprised by the ruling?
Well, we are not really surprised. It's a compromise ruling. It's bad for the plaintiffs, for our clients, because their situation will not change. On the other hand, there are some good parts in it, which are more a task then for the German government in future situations, not to or to be more critical with potential international law violations of its allies.
So what do you think of the reasoning given by the Constitutional Court for this conclusion?
I mean, the case, as you mentioned, is accompanied us for a very long time. So we filed in 2014 in the first court. The strikes that killed family members happened in 2012. So it's been quite a while, and we were seeking protection for the right to life under current circumstances of the clients. And the situation changed in Yemen, also in the global drones program by the US over the years. So the case also was more difficult to win in 2025 than maybe in 2014 or 15 when we filed it. Nevertheless, again, there are some positive aspects, so that it's possible to bring such cases before for German courts for clients that are outside Germany and threatened by attacks from a third party. And also that these cases of international law violations are judiciable in Germany and not only a political question.
Now, what does this ruling now mean in practice? Everything stays as it is, right?
I mean, with regards to drone strikes in Yemen, likely there will be it will have very little impact. But it goes broader. I mean, it's on international law violations. It's on Germany's complicity in those, so it can be relevant and become relevant for other conflicts where international law is being violated and where Germany is still supporting one of its allies. So it can have consequences above this case.
Now, the US says it does not control or carry out drone attacks from German soil. So what is Germany's role in US drone attacks, and why do you think Germany should be held responsible for US actions?
Well, the Ramstein airbase is quite central in the global drone program by the US. Data and signals are going via Ramstein through satellites and then fiber optic cables in real time to drones above in the air sky of the Middle East. So there it's really crucial for the US to have this connection in place. And there's a distributed ground system, which is the largest outside the US, where all data goes through, is being analyzed, and also informs strike decisions. So that's the crucial part. And it's in Germany, so the German government also has a responsibility here in case it's used in an unlawful way.
Very briefly, is this decision final now?
This decision is final. So on the Yemeni case, there is no further instance we can go to.
Andreas Schüller there from the European Centre for Constitutional and Human Rights. Thank you very much.
So let's pick through this with Andreas Zimmermann. He's a professor of international and European law. He's also director at the Human Rights Centre of the University of Potsdam. Welcome to DW. Let's start then with this ruling. And the court found that Germany does not have a general duty to protect fundamental human rights and the core norms of international humanitarian law, even in cases involving foreign countries. That's a direct quote. This duty, doesn't apply to the case presented by the two Yemeni plaintiffs, they decided. Just explain to us why.
Well, as the court put it, there must be two criteria that must be fulfilled. First, there must be a sufficient link between Germany and the action, and whether that did exist in the case at hand was, by the end of the day, left open, but the court hinted that it did. But secondly, there must also exist a serious risk of a systematic violation of the rules of international humanitarian law and international human rights law. And on that, the court said that that would be only the case if there are substantial indications that such violations are not only a possibility, but really a genuine concern. And there the court did find that the targeting policy of the US is still plausibly legal. It might be legal, it might not be legal, but an argument can be made that it is legal. And it's for that reason that by the end of the day, the court did find that there was no violation of the German constitution.
Okay. The United States bounces its control systems off Germany into Yemen. Germany not directly involved, therefore not directly affected by this. But does this ruling mean that Germany could possibly be held responsible in other cases, even if the US doesn't command or carry out drone strikes from German soil?
Well, again, as I said, Germany can be held responsible under German constitutional law if there's a genuine, serious risk of a violation of international humanitarian law by the third state, and if there's a link with Germany. So, for example, inter alia, if Germany is delivering weapons to a situation where there is a serious risk of IHL violations, violations of international humanitarian law by the receiving state, by weapons delivered from Germany, there the court might hold that this could amount to a violation of the German constitution.
So, as far as the German government is concerned, then it's not out of the woods yet. There could be further cases. And just speculating on this, then, a verdict in favour of the plaintiffs, that would have had serious consequences for relations between Germany and the US. So the German government must be breathing a huge sigh of relief at this ruling.
Yeah, well, but this is a hypothetical question. Indeed, it could have had consequences on the US-German relations. But as I said, by the end of the day, the court did not find that the German government had violated the German constitution in the case at hand, because it did find that the German government has some margin of appreciation to determine whether or not the US is violating international humanitarian law by its targeting policy.
OK, Professor, thanks for talking us through that. Professor Andreas Zimmermann, Professor of International and European Law at the Potsdam Center of Human Rights. Thank you so much.
Thank you. Goodbye.